Thank you, Mr. President. I'll be brief in talking about just a couple aspects of the bill that gives just some concern. And it is interesting to note that the Senator for 23rd stated that on the issue of faith-based legislation will be addressed in separate legislation. And that is absolutely fine, and those are issues that can be taken up. But it also is interesting that the issue of HB 359, or dealing with the power of attorney, we believe should also be taken up in separate legislation, because it has a couple of issues that can actually be good but still need to be fought over or discussed in a different form being attached to this particular bill. Specifically, I'm looking at two areas that give some concern over this particular bill. It's on page 102, which is line 3513, which was mentioned, and it was talked about the fact that a potential person who has power of attorney cannot be on a sex registry. And obviously that is very good. But whenever we start talking about dealing with the best interests of children, when we're dealing with the domestic court, there are so many other issues that still come up other than just the fact that the person is not on the sex registry. Whether the person has a criminal background check, certainly that would be a good feature, but a judge is going to look at all sorts of different things even in that criminal background check. Are there theft charges? Are there fraud charges? Is there a simple battery charge? Even just a charge, not even necessarily a conviction. Those are things that a layperson may look at and say, well, that doesn't matter, and cannot necessarily format it and put it all together and understand why, if a person has those particular just charges, not even convictions, but just charges, how that can impact on being able to care for a child, even if it is just for a period of 1 year. So certainly the part about sex registry is great. Certainly the part about giving a criminal background check is great. But certainly a lay person, a young lady, or even two parents who are sitting there looking at that may not be able to put those two things in perspective and realize that even a charge for certain things basically shows that this person may not be in the best interest of the child. And that's something that judges would normally look at. And even if a potential parent was to protest and say, well, judge, that's just a charge for theft. That's just a charge for fraud. That judge many times would rule that that person is ineligible to have parental custody of that child because of those particular charges after they got into the facts and circumstances of the case. That is a very serious concern, especially depending on the circumstances that the young lady or the parents are actually putting the child up for this power of attorney. A second one actually deals with page 103, which is line 3548, which becomes even more problematic, which says an individual should not execute a power of attorney under this article for the purpose of subverting an investigation of the child's welfare. Now that seems pretty obvious. Certainly DFACS has gotten involved. If you do the power of attorney, certainly you can look at that and trace that and say the reason why you did the power of attorney because DFACS was involved. But how about those situations where other family members come into a household, and even if they're not making a threat of calling DFACS, are concerned about certain things? So even though you can't trace that the power of attorney was used for the purpose of subverting DFACS or purpose of subverting the child investigation, in reality, that's exactly why it was used, because other family members or other persons was looking at the situation in the household, and the person who gave the power of attorney realized that even though we have not gotten to the point of actually a formal investigation, this is something that is actually possibly going to happen, and then they go ahead and institute the power of attorney. Those are just two aspects of that bill that's been added onto this adoption bill that are very troubling. Doesn't mean that anybody's a bad person for wanting to put them on there. It just states that why not deal with those two issues in a more formalized way instead of putting it into this whole big adoption bill. Same way we're going to do with the faith-based initiative. Have those conversations in a separate form. And that's one reason why I voted against engrossment, to have these kind of talks, to have this conversation. And so let's do them separately. But those are two issues. Those are two serious issues that do exist in that particular area. I'll yield the well, Mr. President, unless there's any questions.
Senator from the 36, your light is on. Is it in purpose for a question? You are recognized this time for a question.
Thank you. Does the senator yield?
Yes.
I had a question going further on this power of attorney. If you know the bill thoroughly because you all have been working on it in judiciary, and you are a learned attorney, but in terms of this added language, if a parent wants to revoke the power of attorney, how would they go about getting their child back?
Well, I believe the bill does address that. It says that they can do it through written revocation. Now, of course, it doesn't directly state.
Say that again, written what?
Written revocation. They can do a written revocation, and it may actually be insinuated that you could do it orally, quite frankly. So I think that the ability to revoke may be there, but the question is, it's a two-form question. Number one, is it only through written revocation, which is specifically stated. There's no doubt that part is in there. It may be implied that oral could also do it. But the question then becomes, even if you do a written revocation, what has changed in that relationship to where the person who has the power of attorney can still say, well, I believe that me having the power of attorney is actually in the best interest of the child. It does create an issue there. The greater issue is not only about revocation, but the greater issue is not only the two that I pointed out, but to understand the steps that the courts normally go through when talking about best interests of the children. We're talking about parents that come in there, two parents who come into domestic court, and judges have very difficult time between two biological parents determining who is the best interest of the child. Here we have just a layperson, and that's what they are, a layperson now determining that I'm going to give a power of attorney over and really make a judicial decision that judges languish over and that no parties ever come out of that courtroom actually feeling good about. That becomes the problem in this particular situation.
Well, if a parent, further question, if you will accept it, if the parent wanted to revoke the power of attorney, but the parent with possession, the non-parent, refuses to return the child or sends the child to another state, what occurs at that point?
And I think
that seems to be something that's not that atypical, not that hard to understand happening. Wouldn't that be a burden on state and local law enforcement?
And I think what the gentlelady is saying is basically, does this open up some issues that would not normally exist? And the answer to that would be absolutely. It does open up issues that normally would exist. Now you have competition between the biological parent or the parent who's now given over the power of attorney, and does it open up some issues that normally would not be there? And the answer is absolutely yes.
One final question, if you are able to do so. I know that the version that was passed and put on the governor's desk was vetoed, that addressed this non-judicial turning over of children. Have you read the governor's veto message on that? I'm not asking you to speak for the governor, but the governor vetoed this, and now it's been put in another bill. What was the reason for the veto?
I think there's various reasons. One was concerned about the child welfare aspect of it and usurping the ability of DFACS. The language itself covers that. The plain language appears to cover that, but the reality does not cover that. The reality is that when you talk about child investigative services and bringing those into persons' lives, it's not as simple as just, I'm going to go call child investigative services. You know I'm about to go call them, and then somebody executes a power of attorney. What actually happens in many of those situations is families are languishing and going back and forth over this. And so what you're going to find is that the parents will realize that child investigative services may not be called now, but that call is eventually going to be coming. And so the paper trail that I think we're thinking is so simple that we can say, oh, there's no doubt. Here was the investigation. You executed the power of attorney. There's no doubt that we can link the two. I don't think it's going to be quite as simple as what we're looking at.
Thank you.
Thank you. I yield well, Mr. President.
The senator has yielded. Senator has yielded.